discussed together by agreement. Is that agreed? Senator Walsh, to move your Amendment 2.
Okay, I'm happy to move the amendment. The amendment, just to read it into the record, is that where the pregnant mother of an unborn child dies, and that death results in the death of the unborn child, the superintendent registrar in whose registration area where the death occurred must register the death of that unborn child. And then, obviously, a further addition to that amendment would be that the bill abolishes the definition of stillbirth and replaces it with the definition of unborn children to include stillbirths to allow for registration on the Registrar of Deaths. The Minister will be familiar with the general issue, I think, as many people here will be. There has indeed been many instances where a pregnant mother has died or been killed tragically in an accident, and in some instances the baby survive, in some instances they do not. And what we're looking for here is that in those sad circumstances where both mother and baby expire, that there is some way that the family can ensure that that baby's life is recognised on the birth certificate. Now, there's been, I think, discussion on this in the lower house at some stage. I think there's been PQs. The Taoiseach, in a reply, I think some months ago, in February last actually, she said, while understanding that the loss this family suffered is a tragic one, it would not be workable to establish and maintain a separate registrar of deaths in such cases. It is not intended, therefore, to amend the Civil Registration Act 2004 to allow for the registration of deaths without a medical certificate or a coroner's certificate stating the cause of death. Now, I do know that since February, a specific case, which I think clearly highlights the need for this amendment, has been brought to her attention. And I know that she's met the grandfather and other relatives of a child who died in such circumstances. I know she has seen a photograph of the child, which you've also seen, Minister. And this was a young mother who's tragically killed in an accident, and her daughter, who at 7 months gestation, when she was taken from the mother, was actually dead. The baby's name was Molly Enright. And the coroner actually issued a certificate of fact of death. And I, and indeed others in your office, I'm not alone in this, I think have been particularly touched by this case and by the need to have it addressed. And a response that I got from the Registrar General says that when a death occurs, it is registered on foot of a certificate of cause of death supplied by a medical practitioner. Where a death is referred to a coroner, the death is registered by a registrar on foot of a coroner's certificate. He goes on to say that the attached certificate is an interim certificate, and we had sent him a copy of the coroner's certificate, is an interim certificate of the fact of death. Now, it's interesting that the certificate doesn't in any way mention that it's interim. It's also interesting that a certificate of cause of death supplied by a medical practitioner would be sufficient to have the death registered. And also, in the certificate of fact of death, which the coroner states, and indeed the registrar states is interim, does in fact give the cause of death. So that's clearly why the baby died. So it would appear to me that there may be a technical impediment, but there isn't a substantive impediment as to why this birth and other such births could not be registered. Her grandfather, David Walsh, was here. Indeed, her aunt, Hilary, is also here. And I know they're campaigning very strongly on what they feel is an injustice to the memory of Molly, who unfortunately was involved in this accident when she was in her mother's womb. I note that in Section 28 of the Civil Registration Act 2004, which we're amending here, it provides for the registration of stillbirths. And it defines a stillbirth by saying it's a child who at birth weighs not less than 500 grams or has a gestational age of not less than 24 weeks and shows no sign of life in stillbirth. You know, this baby, I'm not sure about the weight, but meets the other criteria in this, because she was 29 weeks or 7 months. And I would strongly appeal to you to consider these amendments. I think they're done for good reason. The parameters you put around it, I'm absolutely open to your views in relation to that. But I think in circumstances, very set circumstances like this, and particularly where you have evidence, of the baby who taken from the mother was dead, baby was dead. It's very akin to a stillbirth, really. It's hard to see major significance between it other maybe than the cause of death. So it's for that reason that these two amendments are being put before you. And I really look forward to your response, and I hope that you can maybe give them serious consideration. There's one other maybe thing that I will add to you, Minister, and that is that I know today that the child's grandfather and his daughter and his sister-in-law who were with him, that they spoke with the Taoiseach, and that the Taoiseach was sympathetic and said she will take another look at this. So I would encourage you to be positive in your response, and hopefully it's something we can have agreed to be included, either the wording that I put down or indeed a different wording if that, if you like, fits the legal requirements better. But I think the principle is one that I would urge that you and indeed the other side of the House would subscribe to.
Thank you, Senator Walsh. And first of all, before I respond, you can actually very much sympathise with the family. And Deputy Ciara Conway also spoke to me on this matter today, and it is very tragic circumstances. And certainly, during this debate, I don't want to say anything that would add to your distress. And certainly, the photograph that you showed me just before I came in will stay with me for a long time. So I just want to say I can well understand your distress, and I hope while you'll never forget, but I hope it gets a little bit easier for you as the days go by. Senator, I don't propose to accept your amendment. The procedure governing the registration of deaths are provided for under Part 5 of the Civil Registration Act 2004 and under Section 4041, where a death is referred to a coroner. The death is registered by a registrar on foot of a certificate provided by the coroner containing the required particulars of the death. Can I also just point out, Senator, that the registrar is actually a lay person, and within your motion say within discretion, and I know to say don't get too much tied up on the wording of it. Can I also say that my department has brought this case to the attention of the Department of Justice and Equality. Coroners are independent, but the service comes under the remit of that department, and you have written to the department. I will be answering that shortly. But certainly, as I said, Senator, I will not be accepting this amendment. And as I said, and then under the Amendment 3, I also will not be accepting the amendment. The registration of stillbirths was first provided for in the Stillbirths Register Act of 1994. The definition of a stillbirth contained in the Act was carried forward to the Civil Registration Act 2004, and the registration of stillbirth is provided for in Section 28 of 2004. And you did read out from a section of the Act yourself, and I don't propose to read it out again, because again, as I say, I don't particularly want to create any distress for anybody here today. But Senator, I will meet with you and I will talk to you again, but certainly I am not proposing to accept the amendments.
Senator Walsh.
Can I just say that I respect the tone of the Minister's response, and I think the fact that he's sympathetic to the family, and I think showed empathy with them as well, is something that I would commend. And also, indeed, I think everybody in the House would send their good wishes to anybody, and particularly to the Enright and Welsh family in this regard, that they will be, that time will help heal that sense of loss. But I think nothing would help heal it more at present than for them to be able to register the death of this child. And I hear what you're saying, but given the Taoiseach's response to the family today, and I'm quite happy actually to accept your invitation of sitting down and speaking with you, would you be prepared to give consideration to this between now and report stage, which is next Wednesday? And I would withdraw and re-enter the motions or the amendments for then. I'd also like maybe to elicit from you a little more. You've relied considerably on the correspondence and on the current statutory position under Part 5. And I obviously accept that, that's the part that's there and you have to deal with it. But on a practical basis, what is the difference between a death in this situation and a stillbirth? Personally, I can see no substantive difference. And where this unfortunate death happens within the parameters of what's set out to govern stillbirths, it really does, I think, invite a reason as to why we would treat them differently. And I respect fully that this is something, I've only spoken to you about this in the lobby before we came in, and I understand that, Minister. And I would like the opportunity to continue that, but I would hope between here and Wednesday that we could have that particular discussion, and that when we come back on Wednesday, that you would be in a receptive mood, if you like, to take the amendments, which I can't see any ramifications or implications within the amendments, other than for the benefit of this family and similar situations that will occur to other families in the future. And like where you have a coroner's certificate, which, clearly sets out the cause of death and the fact of the death, which is more or less, even though it's on maybe a slightly different format, is more or less what is required to register deaths anyway. I think there's a compelling case to be made, that's all. So would you be prepared to do that, to have that discussion between now and next Wednesday, and that at report stage we could debate this again, and hopefully in the meantime, your view might be somewhat different in relation to the particular amendment.
To respond, Minister, in case that there might be a sense, because there would be silence on this side in terms of the contribution made by my colleague, we would fully support this amendment. And also it seems to me that on a reading of section 12 that it's only a matter of a change of wording here, because it states where the death occurs during the first 7 days of life of a child born alive. It only needs a change in the wording. And I fail to understand why there would be resistance to that in light of the information provided by Senator Walsh in this particular case, which would mirror similar cases, sadly, that will happen in the future. Hopefully there won't be many, if any. And I appreciate that you are relatively new to your position. I also understand from long experience in this House that a new minister coming in tends to tread carefully whenever legislation is being processed through the House. That's no reflection on you at all. It's just a natural reaction. I would be exactly the same, as I'm sure everybody else would be, to ensure that you don't make any mistakes or that you don't commit to something that's not feasible or not legally possible. But I would plead with you in this, because it seems like we're pushing an open door on a personal basis, but wearing your ministerial hat, you're somewhat resistant to the argument put forward by Senator Walsh. And I just feel that there is merit in reflecting on the contribution made and there is equal merit on going back to the legal draftsman and looking at this and looking at the wording and at least offering some crumb of comfort to the family immediately concerned about this, but also to other families involved as well. And I don't wish to over-egg the pudding in this regard.
Seanad Clafferdig.
Last fairly, because the headwater that is thought to go hard because as the order came, I don't wish to actually speak on the amendments per se. I just would like to say that Sinn Féin will be abstaining on the amendments that have been brought forward, and we reserve the right to bring forward amendments again at report stage.
Margaret and Tara.
Thank you both, and thank you for your good wishes. Good. Yes, this is a very important, detailed bill, and of course I will tread carefully, and there's a need to tread carefully. But I also want to be extremely sensitive to the family that are here as well, and I can't help but Senator Walsh has probably been a little bit emotional, because it is you can't be if you're a father, but be emotional on an amendment that comes in like this. But like, there is international comparisons, and I'm certainly happy to sit down. But I don't want to give out the false ray of hope at this stage that I will be changing the position to your proposed amendments, because there is international comparisons from the World Health Organization recommending that stillbirths would be defined, and we can sit down and talk about that. But Senator Walsh, I don't want to give the impression, certainly, that I will be amending the bill in relation to this, because it's very important. It's a very important bill. Should be cautious in relation to it. I do accept that your amendments only came in quite late, and we only discussed it briefly. But I am quite happy to discuss with you later on over the coming week. Thank you.
Senator Welch, are you prepared to?
Yes, I recognise what the Minister is saying, and indeed, I don't find any kind of comfort or confidence that you're going to accept the amendments in what you've said. But I think all I would ask is that you approach it in an open-minded way, as I will. But I also haven't heard, but we can discuss this privately between us, I haven't heard any valid reasons, I'm not looking for redefining stillbirths if that's an issue with the WHO, but I'm looking specifically for the circumstances that I've outlined, that they can be, particularly where the coroner is able to issue a certificate. Okay, they'll say it's an interim certificate, but that certificate, interim certificate, is accepted in a whole lot of other cases for social welfare reasons on an interim basis. So, I mean, I can't see any compelling argument, or any reasonable argument, in fact, as to why it shouldn't be done. But I do respect, your position, and I also aware that we only put in the amendments, I think it was on Monday. So, I'm happy to give that time, and maybe afterwards we'll discuss convenient time when we might get together, perhaps next week, maybe next Tuesday if that's suited, and we would go through this. And I'm happy to withdraw with leave to re-enter on that basis.
Amendments 2 and 3, by permission of Senator Welch, have been withdrawn. The question is subject to that Section 12 stand part of the bill. Is that agreed? Agreed. At this stage. Section 13, this question is Section 13 stand part of the bill. Is that agreed? Yes. Section 14, amendment number 4 is a Gordon amendment. I move. It's a new section. 4, 5, 6, 14, 15 and 16 are related and may be discussed together by agreement. Is that agreed? Agreed. On Tara.
Thank you, Chair. There has been uncertainty recently about the definition of a place that is open to the public with regard to where marriages and civil partnerships can take place. Legal advice clarifies that under the current Act, it does not include outdoor venues. The Department conducted a consultation process with the relevant stakeholders. The opinions put forward has been considered in the context of drafting these amendments. The amendments provide a definition for the place that is open to the public, provides clarity to what constitutes a venue in which a marriage or a civil partnership may take place. The amendment provides that the meaning of a place that is open to the public with regards to where the marriage ceremony or civil ceremony registration may take place as follows: a building that is open to the public, or a courtyard, garden, yard, field or piece of ground that is open to the public and lying near near to and usually to enjoy with the building referred to in the paragraph. In order to protect both parties to the marriage of civil partnership, the outdoor venue should be readily accessible to the public to avoid the possibilities of coercion, fraud or lack of capacity on the part of parties to a marriage of civil partnership, to prevent a marriage or civil partnership taking place in secret and to provide an opportunity for objections. The amendment further provides that where the registered solemniser that the couple agree to a place of solemnisation of the marriage, that the place shall be a place that is open to the public as defined. The amendment, sorry, my glasses are getting a little bit fogged up with the heat. The amendment also provides that a registrar may perform the ceremony in places other than their office to include outdoor venues as appropriate for marriages and civil partnerships. The relevant amendment provides further refinement to the Principal Act to ensure that the solemnisation takes place out of doors. The chosen occasion is one which is truly open to the public. The final amendment under the group of amendments is a technical amendment to Section 59 of the Principal Act that provides that the registrar is no longer required to issue a copy of the civil partnership registration form. This is to avoid duplication. Following the ceremony, the registrar is currently required to issue a copy of the civil partnership registration form along with a copy of the civil partnership certificate. The amendment will provide for only one document, the civil partnership certificate, to be issued.
Senator Patrick.
I just wanted to welcome you to the House, Minister Humphreys, my first opportunity to do so, and just to speak very briefly to very much welcome this series of amendments, which in effect just clarifies something that had become an issue over the last year, and that had been raised in particular by the Humanist Association. And we had passed legislation this Seanad, initiated by myself and the Labour Group, to ensure that the Humanist Association would be able to conduct legal wedding ceremonies, and it was Minister Burton who took that legislation through. It then transpired that not just for the Humanists but for others who sought to conduct weddings and civil partnership ceremonies in, for example, the gardens of hotels, that there was an interpretation of the Act that was unduly restrictive. So I'm really glad that we now have that clarified, that in fact a place that's open to the public includes a garden in a hotel and a place like that. And I know that's going to be of great comfort to many couples who are looking to enter weddings, to have their wedding or civil partnership ceremony in that place. Myself and Senator van Turnhout have both raised this in the Seanad. We'd worked with the Minister on it, and I really thank you and Minister Burton for bringing forward these amendments.
Is the amendment agreed? Do you wish to say?
Yeah. Just first of all, can I thank the Senator for the work she's carried out in relation to this, and also thank the Senate for the constructive manner they have dealt with this in the past, especially in relation to civil partnership, and to say it was a job well done by most of the senators here.
Is the amendment agreed? Section 14, some part of the bill, is that agreed? Section 15, Amendment 5, Government, I move, it's a new section, it's already discussed with 4. Is the amendment agreed? Amendment 5? Agreed. Amendment number 6 in Section 15 is Government Amendment, I move, it's a new section already discussed with 4. Is the amendment agreed? That Section 15 stands part of the bill, is that agreed? Section 16, Amendment number 7 is Government Amendment, I move. 7, 9, 10, 11, 12, 13, 17, 18, 19, 20 and 21 are cognate and may be discussed together by agreement. Is that agreed? Minister to move amendment numbers. I move amendment number 7 to speak on amendment number 7.
Sorry. The published bill inserts a new section 58A into the Principal Act, which allows for the validation under Irish law of marriages which took place in embassies in Ireland. This amendment provides that a marriage which took place in a diplomatic mission is also included in the validation process. The published bill also inserts 59IA into the Principal Act. This new section allows for a validation under Irish law of the civil partnership which took place in embassies in Ireland following the enactment of the Civil Partnership and certain rights and obligations of the Cohabitation Act 2010. The further amendment provides that civil partnerships which took place in a diplomatic mission is also included in the validation process.
Amendment number 7, is that agreed?
Agreed.
Agreed. Amendment number 8, Government Amendment, I move. The Minister.
Sorry, I've just.
Number 8. Government, I've already moved it.
Yeah, and this just basically is a deletion of a decree of divorce of, sorry, my Latin isn't great, mentis et torus from the list of decreed eligibilities.
I mean, Setora is from the table and debate.
The Minister explain that.
Huh?
From the Latin translation from my Latin school
Bed
days,
and board, I
from
think it is.
the board or the table and debate. Toro is a bed.
Bed and board.
Why has it been deleted? Is there any? Do you have any?
I'm not going to attempt to answer that. That's what the
No,
Minister
but would the Minister have
I'm
any
interpreting what the-
explanation? I don't want to put the pressure on him at all. I'm just curious. I'm not a legal person, and I'm just interested to know why it's been deleted.
And I just roughly, I just can't find it in the notes, and I know it's struggling there rapidly, but it's just a crossover which happened because of embassy marriages. Sorry, it just had to be handed to me. The amendment provides that this new section allows where a marriage has ended by way of decree of divorce, a mentis et torus, or a decree of nullity. The amendment will not operate as to validate those marriages that no longer exist. So it's really a changeover in relation to legislation. And however, a degree of divorce does not dissolve a marriage, and therefore those marriages require validation. As a result, it is necessary to delete a reference to this type of decree from section 54A 3B, so to allow the marriages to be deemed valid. Senator, if you want a further note on that, I'm quite happy to give it to you.
Well, if the archives could dig up the debate on that and the old Romans in it, it might be interesting. 2,000 years ago. But anyhow, is Amendment 8 is Amendment 8 agreed?
Agreed.
Amendment 9, Government I move, is already discussed with 7. Is Amendment 9 agreed?
Agreed.
Amendment 10, Government Amendment I move, already discussed with 7. Is Amendment 10 agreed?
Agreed.
Amendment 11, Government Amendment I move, already discussed with Amendment 7. Is that agreed?
Agreed.
Amendment 12, Government Amendment I move, already discussed with 7. Is that agreed?
Agreed.
Amendment 13, Government Amendment I move, already discussed with 7. Is that agreed? That section 16 is amended, sent part of the bill. Is that agreed?
Agreed.
Section 17, Amendment 14 is Government Amendment I move. It's a new section. It's already discussed with 4. Is Amendment 14 agreed? That section 17 sent part of the bill. Is that agreed? Section 18 is Section 18 sent part of the bill. Is that agreed?
Agreed.
Section 19, Amendment number 15 is Government Amendment I moved. Acceptance of this amendment involves the deletion of Section 19 of the bill. It's a new section. It's already discussed with 4. Is that agreed?
Agreed.
That Section 19 be deleted from the bill? Agreed. Section 20, Amendment number 16 is a Government Amendment I move. The new section already discussed with Amendment 4. Is Amendment 16 agreed?
Agreed.
That Section 20 sent part of the bill. Is that agreed?
Agreed.
Section 21, Amendment number 17 is Government Amendment I move, already discussed with 7. Is Amendment 17 agreed?
Agreed.
Amendment 18 is Government Amendment I move, already discussed with Amendment 7. Is Amendment 18 agreed?
Agreed.
Amendment 19 is Government Amendment I move, already discussed with 7. Is Amendment 19 agreed?
Agreed.
Amendment 20, Government Amendment I move, already discussed with 7. Is Amendment 20 agreed to?
Agreed.
Amendment 21, a Government Amendment I move, is already discussed with 7. Is Amendment 21 agreed to?
Agreed.
That's Section 21 as amended, sent part of the bill. Is that agreed?
Agreed.
Section 22, the Section 22 sent part of the bill. Is that agreed?
Agreed.
Section 23, the Section 23 sent part of the bill. Is that agreed?
Agreed.
Section 24, Amendment number... Sorry?
Yeah.
On?
Just on are you on Amendment 23 or Section 20?
Section 23.
All right, sorry.
Yeah. Section 24, Amendment 22 is a Government Amendment. I move the Minister to outline the reasons for the amendment. It's Amendment 22, Minister, Section 24.
that the Civil Registration Act 2004, previously under the remit of the Department of Health, consequently Section 2 of the Act defining the Minister, meaning the Minister for Health, that the 2000 civil registration functions were transferred to the Department of Social Protection by way of a statutory instrument. This order provides that where the 2004 Act refers to the Minister, it should now read the Minister for Social and Family Affairs. That Section 66 of the Act was excluded from the order at that time, so that the legislative changes were not required to be made with regard to the meaning of the Minister within the section. This technical amendment provides for the Section 66 now to be amended so the reference to the Minister for Health is changed and refers to Minister shall be construed as the Minister for Social Protection.
Is Section 34, Amendment 22 agreed to? Section 34 as amended, stand part of the bill. Is that agreed?
Agreed.
Section 25, that's Section 25, stand part of the bill. Is that agreed?
Agreed.
Section 26, that's Section 26, stand part of the bill. Is that agreed?
Agreed.
That's Section 27, stand part of the bill. Is that agreed?
Agreed.
That's Section 28, stand part of the bill. Is that agreed?
Agreed.
Section 29, stand part of the bill. Is that agreed?
Agreed.
Section 30 to Section 30, stand part of the bill. Is that agreed?
Agreed.
New sections, Amendment 23, Government, I move, it's a new section, 23 and 25 related will be discussed together by agreement. Is that agreed?
Agreed.
Senator Clerk, would you wish to
Yeah,
speak?
just very briefly on a technical point to say that we are abstaining from voting on this amendment, and 23 and 25 will reserve the right to come back at report stage and bring in amendments.
Do you want to respond to that, Minister? You want to raise something? Okay. Amendment number 3, 23, is that agreed? New section continued, Amendment 24, the name of Senators Van Turnhout, McAneil, O'Donnell, Zapone and Senator Mary Ann O'Brien. It's a new section. And Senator Van Turnhout, do you wish to move the amendment?
I do. I wish to move the amendment. And firstly, may I warmly welcome the Minister to the House. And I want to thank his officials for their correspondence between second stage and now, because there were several issues I raised at second stage, and I got very comprehensive replies. So I just want to acknowledge and thank you, Minister, for ensuring that, but also for the officials who put them together. The amendment that I'm proposing is an amendment to the Adoption Act 2010. And I'd like to thank my group colleagues, Senators Fiach McAneil, Senators Mary-Louise O'Donnell, Senator Cathy Zapone and Senator Mary Ann O'Brien for their support in this amendment. And Minister, I have been in contact with you over the last few days and your officials and your offices, and I'd like to thank you for your cooperation. I'd also like to note and thank Tror, who raised this issue with me, and other individuals who over the past few years have raised this issue. Prior to 2010, before we had the 2010 Adoption Act and we were under the 1952 one, what would happen is if let's take it that I was adopted and I'd apply for my birth certificate, I'd actually get a certificate which said from the Adoptive Children's Register, and it would clearly identify that I was an adoptee and that I was adopted. But in 2010, this was brought in that the state may not disclose, and I know there's a Section 87, but the state may not disclose that somebody is adopted. Now, you know, I believe, Minister, and I think it's very clear in this House, the right to identity, which I know we will discuss when we discuss the Information and Tracing Bill. But even the right to know that you were adopted is absolutely core to the UN Convention on the Rights of the Child. If we look at Article 8 on the preservation of identity, it says state parties undertake to respect the right of the child to preserve his or her identity, including nationality, name and family relations, as recognised by law without unlawful interference. Where a child is illegally deprived of some or all of the elements of his or her identity, state parties shall provide appropriate assistance and protection with a view to re-establishing speedily his or her identity. And in my opinion, the time for a child to know their identity, that they're adopted, it should never be an issue. They should always know. It should never be, that was the day I was told, that was the moment I was told. In fact, they probably, in my opinion, should never remember being told, because it's a fact. and it's just something that you grew up with knowing, and we shouldn't be adding any stigma. But in this case, let's take one example of what I'm talking about to explain to my colleagues why I feel it's so important. If, let's say, a family of a 14-year-old apply for the birth certificate of their child, the family will, the parents apply and they do it all, and they will be told, yes, the child is adopted, but it won't appear anywhere on the birth certificate. So the birth certificate will not state that these are adoptive parents. So it will look, unless you have a very trained eye, it will look exactly like your colleague or your friend who sits beside you in school. It will look like their birth certificate. And they apply for a passport and they get the passport. And because they were under 18, that 14-year-old, when they're 19, will have to renew their passport. But they actually don't need their birth certificate anymore. They just need their old passport. So they don't actually need to go back to the birth certificate. And perhaps it's only when there's a significant life event, like the person is being married, or if they're purchasing property. I was trying to find examples where you would, there's very few examples where you go to look for your birth certificate. But they went to go and get an original because they don't have this original. And it might be at that moment that they find out that they have been adopted. And that, for me, would be a real failure on behalf of the state, that we have covered up and in some way added to the fact that a child does not know, or a young person or an adult at this case, does not know that they have been adopted. I think it's very important. I think we do need to look at it. Minister, I'm not going to be pressing the amendment today because we need to look at the appropriate way to do it. But we can't have a situation, like, for me, there is no stigma about being adopted. So why are we making it as if there is a stigma attached, that in some way we have to cover up that someone has been adopted? Like, we have a shameful enough past to do with adoption in Ireland, and we still have a long way to go. I will, when we get to the Information and Tracing Bill, I feel very strongly, a child being adopted today in Ireland are still denied their right to their identity. We still have a closed adoption system. So the situation for Philomena, and there'll be a BBC programme on tonight on lost babies, we still have the same law. We still cover up. That child has no right to ever know who their natural born parents are. So for me, if we're looking at the Civil Registration Bill, at the very least, we should be giving a signal to that child that they are adopted, that they don't grow up not knowing. We know about medical necessity, that people can often need to know. Your doctor will ask you about your family. If you don't know, perhaps there's something genetic. There's so many reasons why we have to ensure. So for me, I have dealt with several cases over the past few years since the 2010 Act has come into place. I think it's very important that we find a way. I'm not asking for it in headlights. I'm not asking, flashlights that this child is adopted. But we have to annotate that this is not a birth cert. This is the parents who are being listed are adoptive parents. And that is good. That's wonderful. But let's note it in legislation. So that's the purpose of the amendment that I've put down, is that we need to fix this anomaly. I believe it snuck in my opinion. It's maybe was overlooked at some of the consequences. It probably was brought in for good intention, that some people would say as an adult, I don't want to have to explain to everybody that I'm adopted. But actually the unintended consequence is that we could be covering up for children who will never know that they have been adopted, or will always wonder, were they one of the ones who were adopted? I'll never know for sure. And that, for me, is the importance of making this amendment, that we clearly say that somebody is adopted, that we find a way to note it discreetly, but note it. There is no stigma to being adopted.
Sorry, Senator Batchy.
Just very quickly, just commend Senator van Turnhout for raising this. She brought it to my attention earlier today, and I hadn't been aware of the issue, and I just think it's a very good and valid point to be raising at committee stage, and to look forward to the Minister's response.
Senator Turnhout, first of all, can I compliment you on the constructive manner you've dealt with myself and with the officials, certainly up to the last couple of hours. At this stage, I'm not proposing to accept the amendment. But what I would like to do is, over the coming week, to engage further with you and see can we deal with this in a very constructive manner. Thank you for pointing it out, and thank you for your approach to this. I do believe that it was there for very good reasons. We do need to discuss it further and make sure that we do the right thing. And thank you again.
The constructive approach from the Minister, and I will reserve the right to bring it back at report stage, or if we can find a better formulation. I think it is something that we have to ensure, that we don't have a situation where somebody
doesn't know that they're adopted.
Thank you. At this stage, amendment number 4, is amendment being withdrawn by leave of the House. You can re-enter if you wish. Title amendment number 35 is a Gordon amendment. I move. Already discussed in 23. Is the amendment agreed? That this be the title to the bill. An Act to amend and extend the Civil Registration Act 2004, to amend the Immigration Act 2003, to amend the Civil Partnership and Certain Rights and Obligations of Cohabitants Act 2010, and to provide for matters connected therewith. Is the title agreed? Bill report without amendments. With amendments. When is it proposed to take next stage?
Next Wednesday.
Next Wednesday. Next Tuesday. Well, that can be ordered on Tuesday. Yeah. Is that agreed? Yeah.
Agreed.
Would the act? When is it proposed to sit again, acting leader?
10:30 tomorrow morning.
The House stands adjourned till 10:30 tomorrow morning. Thank you. Thank you, Minister. What is that? I'd like to thank Minister Humphreys for attending. First item on the adjournment is raised by Senator Pascal Mooney. 4 minutes. Senator.
And I'd like to thank the Minister for taking this particular matter. It arose as a result of media reportage that there was to be relocation of state jobs from the facility at Tubbercurry in County Sligo, which is currently made up of civil servants from the Department of the Environment and Local Government and from the Department of Social Protection. Following the media comments, local councillor Jerry Lundy raised the issue on local and national media because he had been given to understand, living in Tubbercurry, from those who work on the facility, that it was effectively going to be shut down and that all of the jobs in Tubbercurry were going to be transferred. Now, the background to this is that Eamon O'Keefe, as Minister with responsibility for rural development, I think back in 2006, decentralised sections of his department comprising of about 101 jobs to what was referred to as a temporary facility in Tubbercurry, pending the building of a permanent facility in Charlestown, County Mayo. But naturally enough, as time went on, and we're now into 7 or 8 years since those people moved in, Tubbercurry became very comfortable with the notion that they had so many state jobs, and particularly as Tubbercurry itself has a history of industrial production. The late James Gallagher, who was a member of the other house and a TD for Sligo Leitrim, he created some 450 odd jobs as a result of his entrepreneurial skills, Basta Locks perhaps being the best known of them, and that sadly shut down. So Tubbercurry has had a background of fruitful and positive and productive employment. So you can understand the reaction once that this news started to circulate in the Tubbercurry area. My interest in it is that the Department of Social Protection have a number of jobs there, and the suggestion was and is that they would be relocated to either Sligo and or Carrick-on-Shannon, where there is a Department of Social Protection offices currently operating. When I made inquiries from your department, Minister, they were unable to clarify exactly what the position was, because I was operating, and Councillor Lundy was also operating on rumour and hearsay, but I have confirmed that the Department of Environment are actually being relocated. So the question now is, what's going to happen the Department of Social Protection, your department, and what's going to happen to that workforce there? And I think it would be important that the workforce were reassured, and it's for that reason that I sought clarity on the situation, which I hope you'll be able to provide under the motion that's before you.
Thank you, Senator Mooney. Minister?
Senator, thank you very much for bringing this to my attention. Certainly I wasn't aware of it earlier on. In fact, the Department of Social Protection has 10 members of staff in government building in Teeling Street. So of the 101 of it, is that a total figure you gave me, Senator?
That was originally the figure that went in
that was, yeah, well, there's just 10 members of the Department of Social Protection that are working there. The Department of Social Protection office on Teeling Street is not a public office, which you're probably aware of that, and it administrates the Gateway Scheme, Rural Social Scheme, TUS Scheme, and the Community Services Programme. With 20% of the occupancy, the Department of Social Protection is the minor tenant of the building on Teeling Street, and the Department of Environment, Community and Local Government is the major tenant. DSP has been recently, and I just want to say recently, advised that the Department of Environment plans to permanently relocate their staff from Tubbercurry in the short term. DSP is examining the potential alternative locations to which the work currently being undertaken by DSP staff in Tubbercurry can be relocated. Mayo, Sligo and Leitrim are being explored, but no decision has been made. The options will be available to the staff that currently based in Tubbercurry to move to the location to which the work is relocated if they wish. Every effort will be made to ensure that the staff currently located in Tubbercurry are accommodated with suitable alternative work locations. There will be no impact for customers as a result of the move.
Thank you, Minister. Senator Mooney, you have 1 minute.
Inevitably, the news wasn't going to be very good, but I'm just wondering whether any consideration has been given to retaining even the 10 jobs in Tubbercurry in another location, because obviously they're going to be lost to it. And my understanding as well is that it's possible, not just in your department, but also in the DCLG, that there may be requests for transfers to other departments within the region that would suit people. But ultimately, what is happening here is that the town of Tubbercurry is losing very valuable state jobs that are going to be exceptionally difficult to replace. So you're talking about options being available, but the impression I have from the response, Minister, is that the decision has been taken in principle to move the 10 staff out of Tubbercurry. It's a question of where they're going to go to. Perhaps you maybe might confirm that that seems to be the view, and that's as much as I can do at this stage, other than to plead on behalf of the people of Tubbercurry that perhaps the department might look at retaining the 10 jobs there in a smaller location, which I'm sure wouldn't be beyond the capacity of the department to identify, and as to the reasons as to why they would have to move out of Tubbercurry, I would hope would not be because the Department of the Environment, being the anchor tenant in the building that's a purpose-built building, by the way. It's a modern purpose-built building that's now going to be left vacant completely. So from that point of view, I'm just asking if there's any hope for the jobs to be retained in Tubbercurry.
Minister.
Thank you, Senator, for raising the staff. As I outlined in my initial response, we are quite the minor tenant within the building. I'll do my best to take on board what you've just said in relation, is there a possibility, and how far the decision-making process has gone down. My concerns is that the service that provided by the staff is maintained, and also that the staff that are currently carrying out that practice are treated in a proper manner. But certainly, Senator, I've heard very clearly what you've said, and I will explore in any way I can the alternatives you pointed out to me.
Thank you, Minister. Thank you, Senator Rooney. Minister, are you taking the second item? No. Okay. Minister Ring.
Thank you. Thanks.
The person's not here for the third item, and I don't know what minister is doing yours. You're second, yeah, but the minister's not here. Right. Senator Byrne, you any objection to reversing that will take? Fine.
I do.
I know you can't just.
No.
Okay, Senator. Thank you, Minister Ring. The second item to raise on the adjournment is being raised by Senator Selma Healy-Eames, and I'd like to welcome Minister Ring here. So, Senator Eames, you have 4 minutes. I believe you're sharing time, are you?
Yes, thank you very much, Laska Hurley. And Senator Susan O'Keefe will probably take 1 minute of this time.
Yes.
Now,
Okay.
she actually thought I was on after you, so as a result, she's just left the house. You
Sorry.
know.
Yeah, the way
No,
it
but
works.
just
Yeah.
if we just have a little bit of laughter, could you give her a buzz, if you don't mind, Senator O'Keefe? Yeah, because
Yeah.
she actually
She was here, and then she came up and looked
That's
to see
right,
that
that's
she
right.
was the third item, that your item was the third item. But the Minister for Senator Burns is not here, so we're
Okay,
proceeding.
no problem
Okay.
at all. Minister, you're very welcome. And listen, great to have you here to answer this motion.
Time now. I'll start your time
Start the
now.
time now. My motion is very simple. We're facing into a wonderfully big year in the life of W.B. Yeats. It'll be the 150th anniversary of his birth next year. And my motion is to ask the Minister for Tourism to ensure that Fáilte Ireland would consider providing a licence to the Yeats Tour Ballylee Society, of which I'm chair, to enable a fundraising to begin so that Tour Ballylee, which is the ancestral home of W.B. Yeats, could be opened on time for Yeats' 150th birthday in June 2015. So anyway, here's Susan O'Keefe, so this is great. So let me just give you the story, Minister. Just a year ago, we set up this local committee, and I was asked to chair it. And it's really to celebrate the life of W.B. Yeats. Up to 2009, Tour Ballylee, the ancestral home of W.B. Yeats, situated in South Galway, near Gort, near Lady Gregory's Cool Park, and near the Kiltartan Museum, and that entire area that's dedicated to the life of W.B. Yeats and the trials and tribulations of the man in South Galway. We set up this committee to reopen Tour Ballylee because it was closed in 2009, Minister, after the flooding. Now, to be fair, it's now under the remit of Fáilte Ireland. Fáilte Ireland have been straight up with us. They cannot afford to reopen it, and they can't afford to run it. However, they're on our committee, and they're very committed to having it handed over to a group such as Galway County Council, in conjunction with ourselves, a community group. Just to say, the newly named Yates Tour Ballylee Society is made up of myself, Ronnie O'Gorman, who's he's the secretary. We have a number of local businessmen. We have real community activists. We have Fáilte Ireland. We have Galway County Council. We have Galway Rural Development. And at our last meeting, we had Senator O'Keefe visit, who happens to be the national chair of Yates' 150th birthday. So she knows what we're trying to achieve. Now, here it is in a nutshell, Minister. We need probably, according to Fáilte Ireland, we need about 400,000 to reopen this. Yeah, but just listen to this now for a second. Yeah. We've had it assessed by people in the know that would be tendering for this. They don't believe we need anything like that. I just toured it myself. It's in great shape. It needs cleaning and maintenance. However, we don't dispute that money is needed, not just to open it, but to run it. We have umpteen requests on our books offering to give us money, but we're not able to take the money. We have the money being offered from America, from the UK, from Ireland, but we cannot take the money unless we have a licence to run it. So we're asking for the following, Minister, just to give us a licence for 1 year to enable us to fundraise it, to get past his 150th birthday, so we can open Tour Ballylee, not just for Ireland, but for the nation and for the world, to be able to join with Sligo as well in the overall picture for Yates. We are quite convinced then, Minister, that we will hand back a Tour Ballylee to Fáilte Ireland or to Galway County Council or whoever is ready, and we will work with them in a community-based linked initiative to ensure that this is run. We have an army of people ready to do this.
Sure,
we are totally committed. I'm delighted that you're listening as well.
Senator O'Keefe, the Sligo person will not have any time.
Oh, yeah.
No, thank you, Senator.
Less than 1 minute, Senator.
And Minister, you're obviously aware of the 150th celebrations, and you know that the commitment that we gave to the Taoiseach and to the Department of the Arts and indeed to the Department of Tourism was that this would be a nationwide endeavour. And so it's important people visiting from other places in the world don't care about the border between Galway and Sligo. They just want to go to see the places that are associated with Yates. I would like to give my support to this request for this to be given in the care of the community for the year, so that we can open it in 2015, so that people can come and enjoy the place as a beautiful place in its own right and as part of the Yates story, and that indeed in so doing they will raise the funding, we will all raise the profile, and indeed the tour, the tower, will be restored for the nation and for the world. Thank you.
Thank you, Senator. Minister.
Thank you very much, both senators. I am pleased to attend the channel tonight to discuss the future of Tour Ballylee and to hear from Senator Healy Eames. And Senator, I want to also welcome you here this evening and thank you. The progress that has been made locally to open Yates' former home. Senators will be aware from previous debates on this topic, Tour Ballylee is a former holiday home of W.B. Yates. Yates purchased the property in 1916, and it is only a few miles from Cooley Park, the home of his lifelong patron and friend, Lady Gregory. The Tower House was given by Michael Yates, Yates' son, to Ireland West Regional Tourism Authority and transferred to Fáilte Ireland in 2006, when the Regional Tourism Authority was merged with Fáilte Ireland. On taking over the Regional Tourism Authority, Fáilte Ireland also took on the operation of the network of tourism information offices throughout the country. The management and staffing of these offices, their opening hours and their location are a matter for Fáilte Ireland and its management. Given the pressure on the public finances and in response to changes in the needs of tourists, Fáilte Ireland, like many other state agencies, continued to reshape its services. It is also prioritising the locations where tourism information offices are provided. As part of this, Fáilte Ireland has been working in partnerships with local communities. To date, approximately 40% of tourist information offices across the country have been taken over by local authorities, chambers of commerce and community groups. Fáilte Ireland does not operate tourism attractions, and where it has inherited attractions, it has sought to dispose of its interests at an appropriate stage. In relation to the situation at Tour Ballylee, senators will be aware that this area of Galway was badly affected by flooding in 2009. The Tower House badly damaged by this flooding and has been closed ever since. In 2012, Fáilte Ireland spent $200,000 in weatherproofing the building and protecting its fabric, and further works will be required if the building is to open again. However, This future investment would not represent value for money for Falch Ireland. This is because the number of visitors who sought tourist information when the house was open was too small to justify spending scarce resources on reopening the building as a tourist information office. In that light, Falch Ireland has been exploring other options for its future operations and seeking the involvement of interested parties to operate the Tower House. In regard to the Yates Tour Bandely Society, Falch Ireland, and I want to say this, when I got to the inn yesterday, I made contact with Falch Ireland and I asked them, and I want to say, I understand that Falch Ireland has written today to say that it is agreeable to granting them a licence subject to clarification of a number of issues. I would encourage the Society to work with Falch, and I wish them the best of luck, and I hope that we have a very successful house.
Just say how grateful I am, Minister. This is good news. It's the first day of Seanad Éireann's new term. WB served in this House from 1922 to 28. His